Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
Welcome to our Thursday morning lecture at the International Law Program from the International Law Center. My name is Gustavo Vieira. I teach international law at the Federal University for the Latin American Integration here in Brazil, in Foz do Iguaçu. And I'm very honored to be with you today and to be the moderator of our distinguished speaker, Professor Concepción Escobar Hernandez. And I will try to be short on her curriculum, and very incredible curriculum. She holds a degree and a PhD in law by the Complutense University of Madrid, chair in public international law of the National Distance Education University, UNED, where she is a professor nowadays, and she's member of the International Law Commission by the United Nations. So those are very distinguished items in her curriculum, but she's also professor of international law at the Diplomatic Academy of Spain. She also is professor of the University Institute of General Gutierrez Melado and of the Center of International Studies of Humanitarian Law by the Spanish Red Cross. She has been part and head of several Spanish delegations before international organizations and conferences, of which the Rome Conference on the Statute of the International Criminal Court and the Kampala Conference on the amendment of the Rome Statute, of which she was president of the drafting committee, are worth mentioning. So those are very interesting topics. She is also dedicated in the following matters: immunities in international law, international human rights law, international criminal law, international tribunals and settlement of disputes. And she's also a member of the Scientific Council of the Elcano Royal Institute of International and Strategic Studies. So, Professor Concepción Hernández, muy bienvenida a nuestra clase de Derecho Internacional. Es un placer estar con usted. And she's going to work with us today the issue of immunity of state officials in international law. So the International Law Commission is developing this issue, and Professor Concepción is in charge in this developing in international law. And just to remember you, we have usually in the international law course this issue of immunity of states. And this has long development in international law. And this is the topic that we are going to hear today. Professor Concepción Hernández, this virtual floor is yours. Welcome.
Thank you very much. I hope that you are hearing me. Yeah, okay. Thank you very much. First of all, I would like to thank the Dean and in particular Professor Temer for the kind invitation given to me to participate in this course of international law, which is a very well-known course in the Americas. It is my pleasure and my honor to participate in that edition. And I very much appreciate the fact that you have been you have allowed me to choose choose the topic, because that has permitted to me to speak about one topic which is very important for me, in particular because I can speak on my capacity of a special rapporteur of the International Law Commission on immunity of state officials from foreign criminal jurisdiction. Thank you again to Professor Vieira for your kind presentation, for your kindness in using Spanish language in the introduction. And I can understand Portuguese, but I can speak Portuguese, but at least I can say muito obrigada. Good morning to everybody. I will start with a brief presentation of my topic today. Let me start by underlying the idea that immunity has always been considered by international law from the perspective of sovereignty as a tool to protect the sovereign prince, first in the past, and to protect the state's sovereignty afterwards. From this perspective, the principle par imparem not habent imperium is the most common rule alleged before domestic tribunals in order to claim state immunity. However, a great evolution has taken place during the last century regarding the law of immunities. One of the most remarkable new trends has been the progressive recognition of a kind of immunity, named also sovereign immunity, with regard to the head of states and other state officials. This trend has been developed alongside with a limited process of codification of the law of the immunities and a new interest from international courts, in particular International Court of Justice, the European Court of Human Rights, and the International Criminal Court on the institution of immunity in international law. In this framework, I would like to draw your attention about the emergence of a new and deep process of reflection about immunities at the beginning of the 21st century. This reflection focused mainly on the following issues. Whether it exists only one sovereign immunity, the state immunity, or if there are a coexistence of various kinds of sovereign immunities, so immunity of state immunity and immunity of state officials. Second, the identification of the legal basis for sovereign immunities, including whether there are one or more bases. Third, which are the scope of sovereign immunities, including the possibility of identifying different scopes depending on the various types of immunity. And fourth, the relationship between immunity and legal values and principles of international law. In particular, the relation between immunity, international crimes, and serious breaches to human rights and international humanitarian law. Immunity of a state official is in a central position in the new scenario of immunities. This type of immunity became a privileged laboratory for analyzing and identifying the new trends arising around a classic but changing legal institution. As you can imagine, it is impossible to address all the issues related with the immunity of state officials in only 2 hours. But I will intend to address the most relevant issues. So that I plan to speak today about the origin and evolution of the immunity of state officials and about the main characteristic of this kind of immunity. And tomorrow I will deal with the work of the ILC on immunity of state officials and the relationship between the immunity of state officials and international crimes. Moving to the first issue, I would like to recall that the treatment of immunity of state officials in international law has experienced a very significant evolution, which could be qualified as a round trip. From a historical perspective, immunity in international law appears as the immunity of the prince, who, as the holder of sovereignty, cannot be subject to the courts of another state, not to other coercive measures. Thus, immunity is, in its own origin, a personal immunity of the prince. In any case, immunity is based on sovereignty, and therefore, when sovereignty ends to be a personal attribute of and is considered as element pertaining to a state itself, immunity becomes the immunity of the state, free from any personal or individual component. This new approach will be reflected in several decisions taken by national courts through the 19th century, and as a result of the expansion of the scope of international relations, the interest of international law to immunity has been deviated from the immunity of the sovereign prince to the immunity of the sovereign state, even from the perspective of codification. So the adoption of the European Convention on Immunities or the adoption of the United Nations Convention on Jurisdictional Immunities of State and their properties are very clear examples of this development. However, the issue of immunity of state officials continue to be present at international level nowadays. I would like to offer you some examples that can illustrate that assessment. First, in the context of the two world wars, there were some attempts to prosecute Kaiser Wilhelm, First World War, and the Nuremberg and Tokyo courts were created. In both cases, immunity of a state official has been alleged. Second, Immunity has been continuously alleged to prevent national courts for exercising their jurisdiction over head of state, head of government, foreign minister, and other high-level state officials. See, for example, the Gaddafi and Obiang cases in France, the Gerodia and Sharon cases in Belgium, or the Pinochet, Castro, and Kagame cases in Spain. Third, some national courts have decided not to exercise their jurisdiction in respect of certain acts, including torture, committed by senior state officials on the grounds that they were protected by state immunity. See, for example, Al-Dassani and Jones cases in the UK. Other tribunals, on the contrary, have not recognized such immunity. For example, and it is an example also from UK, the Pinochet case. Four, we have to take into account that some courts have also ruled on the immunity from civil jurisdiction of state officials, in particular in those countries which legal system permit to claim damages based on breaches of international law committed by foreigners, including state officials. See, for example, the Alliance Tort Act in the United States. Five, some national acts have made reference to the immunity of a state official of the foreign state, either with relation with the immunity of a state, the traditional immunity of a state acts, in particular in the Anglo-Saxon countries, and in regard with the process of implementation of the Rome Statute of the International Criminal Court. Sixth, the immunity of jurisdiction of a state official has been included in several treaties. And seventh, the International Court of Justice, the European Court of Human Rights, and the International Criminal Court have ruled on several occasions on the immunity of state officials, always from the perspective of international law. In short, the immunity from jurisdiction of state officials continue to form part of the law of immunities in contemporary international law, although their own characteristics are far from the original immunity of the sovereign prince. This modern manifestation of the immunity of a state official is undoubtedly an issue of great interest to states and to the international community, which has also reached a special significance since the 80s of the last century, when in particular with relation with the moment when the particular problem of immunity from criminal jurisdiction and its possible impact on impunity from international crimes begins to arise as a very important issue. This increasing relevance of the immunity of state officials in international law has had as a consequence the adoption of new rules of international law, most of them conventional rules. At the first stage, the issue of immunities of a state official was not considered in itself, but as a component of the general regimes applicable in the field of diplomatic relations and in the field of the armed force stationed abroad. Regarding the immunities in the field of diplomatic and consular relations, 4 treaties must be mentioned. First, the Vienna Convention on Diplomatic Relations. Second, the Convention on Special Missions. Third, the Vienna Convention on the Representation of a State in their relation with international organizations of a universal character. And fourth, the Vienna Convention on Consular Relations. All of these conventions have been adopted on the basis of draft articles elaborated by the International Law Commission. Thus, the legal regime applicable to the immunity of state officials set out by them follows the same model. The main characteristics are the following. First of all, there are a multiplicity of individuals covered by immunity. Second, there are different immunities regime. Third, immunity can be alleged before civil, criminal, or other kind of domestic jurisdiction. And fourth, the legal basis of immunity is foreseen as the protection of the sovereignty of a state, and its purpose is to protect the function of the state representatives abroad. The Vienna Convention on Diplomatic Relations could be considered as the more general and comprehensive of this convention, and for this reason, I will limit my following comments to it due to the time restraint we have. Under the Vienna Convention, immunity applies to diplomatic agents, the head of mission and other diplomats, but also to other categories of individuals linked to the diplomatic mission, in particular, the administrative and technical staff, the service staff, and finally, to the members of the family of diplomatic agents. Persons in all these categories are granted some form of immunity from jurisdiction, even if the scope of that immunity varies for each category. The immunity extended to diplomatic agents is the broadest, and the immunity extended to members of the service staff is the narrowest. The common element in the recognition of the immunity of these persons is that they perform certain functions in the service of the sending state, with which they have a formal connection, regardless of the legal nature of that connection. That could be whether statutory or contractual. There is no doubt whatsoever as to the nature of this function, as they are referred to in the Convention. They are public and official functions and activities. In short, they are all performed for the purpose of carrying out the functions of a diplomatic mission, which are a clear manifestation of governmental authority. It should be also be borne in mind that the Vienna Convention on Diplomatic Relations accords particular importance to the special connection between the aforementioned categories of persons and the state, namely nationality. Although that connection is not critical for the performance of diplomatic, administrative, technical, or service functions in a diplomatic mission, it has a bearing on the regime applicable to immunity from jurisdiction. In short, it is the connection with the state and action on behalf of the state and the performance of official activities for its benefit through the diplomatic mission that make it possible to recognize to state officials some forms of immunities. The only exception to this rule is the case of the family of the diplomatic agents, who, even if they don't exercise any activity or function on behalf of the state, enjoy some kind of diplomatic immunity in order to protect the independence of the diplomatic agent. At any rate, although the family of a diplomatic agent enjoys immunities, they cannot be qualified as state officials, of course. However, the immunities regime set up by the Vienna Convention made a clear distinction between diplomatic agents and other members of the mission. For diplomatic agents, the immunity is linked to the person in charge of the exercise of the true functions of state representation. As a consequence, the scope of immunities they enjoy are designed in a broad way. So, in accordance to Article 29 and 31, the diplomatic agent, first, he enjoys immunity from criminal, civil, and administrative jurisdiction, with some limited exception, of course, but related only to civil immunity. He is not obliged to give evidence as a witness. No measures of execution may be taken in respect of him. And finally, his person shall be inviolable, and he shall not be liable to any form of arrest or detention. In addition, immunity of diplomatic agents covers both the acts performed in an official capacity and their private acts, and no limitation or exception to immunity from criminal jurisdiction exists. However, it must bear in mind that this kind of immunity is applicable only during the term of office of the diplomatic agent. When this term ends, immunity remains only with regard to the acts performed in an official capacity. The scope of the immunity enjoyed by other members of the diplomatic mission is more reduced, being limited to acts performed in an official capacity. Thus, the Vienna Convention on Diplomatic Relations has established two different categories of immunity linked to person, the diplomatic agent, or to the acts performed, the other members of the mission. Both categories are on the basis of the distinction between immunity ratione personae and immunity ratione materiae, which are well-known concepts in the framework of the immunity of state officials. Moving to the second field, when immunities appears, I would like to say some words about immunity of armed force stationed abroad. This type of immunity has been approached both from the perspective of the state immunity and from the perspective of the members of the armed forces and the civil staff accompanying the troops. Regarding the immunity of members of armed forces, it has been addressed always by conventional rules contained in bilateral treaties, or more recently in the agreements on the statute of forces, the SOFAs. Due to the specific characteristic of this kind of activity, the issue of immunity usually doesn't appear always in an express manner, but sometimes under the form of a system of distribution of jurisdictional competence. But at the same time that this convention and agreements have included some rules related to immunity of a state official, it has emerged a customary rule on the immunity of head of state and other high-rank officials. It is an autonomous rule devoted exclusively to immunity of state officials. The existence of that customary rules have been recognized in particular in the Convention of Special Mission and in the Vienna Convention on the Representation of State in the relations with international organizations of a universal character. Both conventions declares that the head of state, the head of government, the Minister of Foreign Affairs, another minister or another high-ranking authority of the state acting as a member of this special mission or acting as a mission before an international organization enjoys not only the specific immunities established by convention, but also the immunities that international law grants to those categories of state officials. In addition, the existence of this customary rule has been recognized by the International Court of Justice in the arrest warrant case. More recently, the international criminal law has recognized the existence of a customary rule of immunity of the head of a state in the judgment issued on the Jordanian case, to which I will refer tomorrow. And the same assessment has been made by several domestic courts facing the issue whether to exercise or not their jurisdiction with regard to head of state and other high-rank officials. This customary rule has set up an autonomous legal regime on immunities applicable before both civil and criminal jurisdiction, which relevance in contemporary international law can be denied, although if its scope continues to be uncertain and sometimes controversial, as show the domestic and internal case law, and even the works of the International Law Commission and the doctrine, including the Institut du droit international. This autonomous legal regime on immunities of state officials present some specific characteristics which merit to be highlighted. First, immunity applies to head of state and other high-ranking state officials, but it could be applied also to other state officials in case they have performed acts in an official capacity. Second, the legal regime applicable to different categories of state officials is different, so it must be made a distinction between immunity ratione personae and immunity ratione materiae. Third, immunity of state officials applies from civil, criminal, and administrative jurisdiction. Fourth, immunity of state official is different to state immunity. And fifth, immunity of state official must be understood as immunity from foreign jurisdiction, not as immunity from international jurisdiction. I would like to make some comments on the certain some comments about this characteristic, in particular on the following issue. First of all, the distinction between immunity ratione personae and immunity ratione materiae. Second, the relationship between immunity and jurisdiction. And third, the distinction between immunity of state officials and state immunity. I will start with the distinction between immunity ratione personae and immunity ratione materiae, because I think that is one of the main characteristic elements of the immunity of state officials. The distinction between immunity ratione materiae and immunity ratione personae is a classic one, and they are referred also as personal immunity with relation to the immunity ratione personae, and functional immunity with relation to immunity ratione materiae. In fact, they are the same, the content is the same, even if I prefer to use the terminology of immunity ratione materiae and immunity ratione personae in order not to provoke a confusion about the nature, the functional nature of any immunity of the state officials. The distinction between both categories has been well established by doctrine on the basis of focusing mainly on the person enjoying immunity, immunity ratione personae, or on the acts covered by immunity, immunity ratione materiae. Although this distinction is not defined by any legal test, the analysis of practice permit us to conclude on the identification of three different elements. First, immunity ratione materiae applies only to several state officials of high rank level, in particular the so-called troika, and immunity ratione materiae could apply to a broad range of state officials. Second, immunity ratione personae covers both private and official acts, and immunity ratione materiae covers only acts performed in an official capacity. And finally, immunity ratione materiae applies only during the term of office of the state officials, but immunity ratione materiae has not a temporal limit. The distinction between immunity ratione personae and immunity ratione materiae is not a mere theoretical distinction. On the contrary, this distinction has some important effects on the distinction between immunity of state officials and state immunity, and it is the basis for the establishment of, for setting up of different legal regimes applicable to each kind of immunity of a state official. With regard to the relationship between immunity and jurisdiction, I would like to draw your attention on the fact that immunity and jurisdiction are the two basic concepts it must be taken into account in order to identify the institution of immunity of state officials. Consequently, although the concepts are separate from one another, as currently noted by the International Court of Justice in the arrest warrant case, only the relationship between them explains the content of the institution of immunity in international law. The concept of immunity is by necessity based on the prior existence of the criminal jurisdiction of the state, without which the institution of immunity itself would be meaningless. Consequently, it is first necessary to determine what we mean by jurisdiction. Jurisdiction is a generally accepted term that is an uncontested component of all domestic legal system under which immunity can be invoked. It means the competence for domestic courts and tribunals to settle any dispute or case relative to the interpretation and or application of national law. Thus, it is a concept strongly linked to the judiciary activity. Jurisdiction can be on civil, criminal, or other matter, as I said before. So, as a rule, we can make a difference between immunity from civil jurisdiction and immunity from criminal jurisdiction, on the understanding that civil jurisdiction, immunity from civil jurisdiction covers also the immunities before other jurisdiction different than criminal. Although both of them must be considered as immunity of state officials, some differences could exist between the legal regime applicable to one or another. Finally, jurisdiction must be understood exclusively as foreign jurisdiction, not as international jurisdiction. Thus, immunity of state officials only applies with regard to the domestic courts and tribunals. Like the term jurisdiction, the term immunity is not usually defined in the international instrument that in one way or another have dealt with the immunities of a state or its officials or agents, including the United Nations Convention, the Vienna Convention on Diplomatic Relations, and the Convention on Special Missions. Generally speaking, normative practice has in the past tended simply to mention immunity from jurisdiction as one component of the regime of privilege and immunity set out in each of those instruments without defining it. Although it could present us with a nebulous legal concept, the task of integrating this nebulous legal concept is not particularly difficult, since the concept of immunity from jurisdiction was the subject of lengthy discussions, including within the International Law Commission during the travaux préparatoires of the aforementioned instruments. A set of characteristics of the concept of immunity from foreign jurisdiction has emerged, which can be summarized as follows. First of all, immunity prevents a state from exercising its criminal jurisdiction, even though its courts would, in principle, be competent to exercise its own jurisdiction. Second, immunity arises only as a result of the existence of a foreign component, referred to generically as an official of another state. And third, immunity from foreign jurisdiction is by nature mostly procedural, although it is necessary to introduce some nuance in certain cases related to immunity from foreign criminal jurisdiction, to which I will make reference tomorrow. In any case, as jurisdiction is an inherent power of the state, we can draw several relevant conclusions from a methodological perspective with regard to the nature of immunity. These conclusions could be expressed in the following form. First of all, immunity is a limitation or exceptions to the exercise of the jurisdiction by the territorial state. Second, as a limit to a sovereign power, immunity must be understood under theological terms. Immunity is recognized in order to protect values, principles, and interests of the international community, in particular, the equal sovereignty, the free and peacefully exercise of the state functions, and the stability of international relations. The scope and meaning of immunity must be limited to the achievement of the purpose previously mentioned, and exclusively in order to protect the state interest and not the official interest. And finally, the relation between jurisdiction and immunity must be considered in a dialectic way in order to set up a fair balance between the rights and interests of the foreign state, jurisdiction, and the official state, immunity. That fair balance must be identified case by case on the basis of the applicable rules, values, and principles. Finally, I would like to make some comments with regard to the relationship between immunity of state officials and state immunity itself. It should be borne in mind that the immunity of state officials has traditionally been viewed as a form of state immunity and has been conflated with that concept. It is not unusual to find reference in legal practice to the idea that state officials enjoy the same immunity enjoyed by the state. This view has led to the conclusion that the immunity of state officials from jurisdiction, is not an individual immunity, as it derives from state immunity, the legal regime of which is fully applicable to immunity of state officials. This conclusion is, this approach is the outcome of various arguments, including the following. First, immunity from jurisdiction enjoyed by a state official is a consequence of the principle of the sovereign equality of states, as expressed by the phrase par imparem not habet imperium. Second, immunity is recognized in order to protect state sovereignty and ensure that international relations can be carried on peacefully and sustainably. Third, the immunity of state officials is not in fact immunity of the officials, but immunity of a state, as demonstrated by the state's freedom of choice with regard to such immunity, including the freedom to live or waive immunity. And finally, this identification between immunity of state officials and state immunity is based on the idea that bringing suit against a state official in a foreign court is an indirect way of bringing suit against the state when the latter cannot be prosecuted in the courts of a third state, meaning that the official's immunity from jurisdiction serves as a safeguard against frivolous challenges to state immunities and is therefore equivalent to state immunity. These arguments certainly contain valid points that cannot be denied, especially the fact that officials are given immunity from jurisdiction in the interest of the state and in order to safeguard values and principles that pertain solely and exclusively to the state. Even so, the arguments fail to consider other factors that must be taken into account in order to determine how the immunity of state officials from foreign jurisdiction is related to the immunity of the state. In order to find an adequate response to this issue, it is necessary to make a distinction between immunity from civil jurisdiction and immunity from criminal jurisdiction. The link between state immunity and immunity of state officials is more clear and stronger in the case of immunity from civil jurisdiction. However, this conclusion, the stronger link between state immunity and immunity of a state official, is not evident in the case of immunity from criminal jurisdiction. In particular, because the criminal nature of the jurisdiction has two major consequences. First, the object to which the jurisdiction claims in such cases directly relate is the individual. And second, any consequences of the outcome of the criminal proceedings are individual and strictly personal. This creates a direct link between the individual and immunity from foreign criminal jurisdiction. It should also be noted that a state can never be prosecuted in national criminal courts, as any responsibility it may have for criminal acts committed by its official will always be of a civil nature and can only be determined in civil courts by means of a claim for compensation for the harm caused by such acts. That implies a distinction between immunity from civil jurisdiction and immunity from criminal jurisdiction, which must be duly taken into account. From the two elements mentioned above, it must be concluded that immunity of a state official is different from state immunity, in particular with regard to immunity from foreign criminal jurisdiction. This assessment is crystal clear with regard to the immunity from jurisdiction ratione materiae, which is individual in nature and distinct from the immunity of state stricto sensu. This is true even though this distinction is not always made with sufficient clarity in the literature and in practice, largely as a result of the traditional emphasis of the state and its right and interest as the beneficiary of the protection afforded by immunity. While the state undeniably occupies a central position in this institution, the protection of its rights and interests is nevertheless an insufficient reason to conclude that immunity of a state and immunity of state officials are one and the same, just as identity of purpose, as in the case of state immunity and diplomatic immunity, does not mean that the two types of immunity are identical. Rather, in order to gain a proper understanding of the institution of immunity of a state official from foreign criminal jurisdiction, ratione materiae, it is necessary to distinguish between the direct beneficiary of immunity, the state official, and the indirect or ultimate beneficiary of immunity, the state. Immunity ratione materiae is recognized in the interest of the state, which has sovereignty, but it directly benefits the official when he or she acts in expression of such sovereignty. The distinction between immunity of a state and immunity of its officials from foreign criminal jurisdiction is not a mere theoretical construction. It has been reflected in a number of judicial decisions adopted by both national and international courts. Regarding decisions at the national level, it suffices to recall the different ways in which the House of Lords, the former High Tribunal in the UK, deal with immunity in Pinochet case number 3, in Price Nasser case, and in Jones case, based on the different nature, criminal and civil respectively, of the proceedings in which immunity was invoked and on the consequences of that difference in terms of immunity. Of particular relevance is the case Sementar versus Yusuf, in which the Supreme Court of the United States held that a state official cannot be deemed to be included in the concept of a state within the meaning of the Foreign Sovereignty Immunity Act, and that the immunity of such an official is subject to rules that differ from those applicable to the immunity of a state from prosecution in that country's courts. Of greatest relevance are as well the decisions of international courts that have expressed or implied made a distinction between state immunity and immunity of state officials. The International Court of Justice in jurisdictional immunities of state case acknowledged this distinction by affirming that, I quote, "The court must emphasize that in the judgment, it is addressing only the immunity of the state itself from the jurisdiction of the courts of other states. The question of whether, and if so, to what extent, immunity might apply in criminal proceedings against an official of the state is not an issue in the present case." The court also expressed acceptance of the distinction between immunity of a state and immunity of state officials in referring to the way in which national and international courts have dealt with the distinction between civil and criminal jurisdiction and its consequences for immunity, and in referring to its own jurisprudence. The European Court of Human Rights in Jones and others versus United Kingdoms have produced a relevant, a very interesting judgment, who is highly relevant since, as the court notes, the applications refers to a case of immunity which, unlike the one in Al-Dasani, was brought before the British courts against individuals and not against a foreign state. The court nonetheless applied the traditional doctrine that state immunity applies also to individuals. This conclusion, however, requires a nuanced view, as the court made clear in explaining the legal grounds for its judgment that its decision refers exclusively to immunity in the context of civil cases, and alludes to the possibility that a different approach may be taken when immunity is invoked in criminal cases. The differentiation between the immunity of state officials from foreign criminal jurisdiction and the state stricto sensus is still more evident in the case of immunity ratione personae, as an official who enjoys such immunity, a head of state, head of government, or minister of foreign affairs, may do so even in respect of acts which are performed in a private capacity and which thus are not attributable to the state and do not engage its responsibility. In such cases, the immunity of these three officials from foreign criminal jurisdiction for a criminal act committed in a private capacity has no equivalent whatsoever in the realm of state immunity, And yet, even in these cases, such acts are covered by a form of immunity from foreign criminal jurisdiction that is recognized also for the benefit of the state, not of its official. Taking into account the previous consideration, the following conclusion may be drawn. First, state immunity is typically assumed to apply in respect of acts which are attributable to the state alone and for which the state alone can be held responsible. Second, when an act is attributable both to the state and to an individual, and both can be held responsible, two types of immunity can be distinguished: immunity of the state on the one hand, and immunity of the official on the other. And third, the differentiation between immunity of a state and immunity of state officials is clearest in respect of the immunity of a state official from foreign criminal jurisdiction, given the different types of responsibility attaching to the state, civil, and to its officials, criminal, and the different nature of the jurisdiction from which immunity is invoked. Finally, I would like to call your attention on the fact that concluding that immunity of a state official is different from state immunities is not, again, a mere academic issue. On the contrary, because of the autonomous character of immunity of state officials, it is possible to conclude that immunity of a state official is submitted to its own legal regime, including the possibility to apply some exceptions to immunity in several circumstances. Well, I think that I have made all the comments, general comments I would like to give you today with regard to, from a general perspective. And I only want to make a final remark. The issue of immunity of state officials works nowadays on a special role in international law, in particular because immunity of state officials are pursued by states as a tool for defend our own rights, our own interests before other countries, and sometimes in order to avoid the so-called intervention in domestic affairs. So immunity of a state official has a very, very strong political component, and I think that it is an issue, and it is a controversial issue both from legal and political perspective. But at the same time, we have to take into account that the issue, the legal regime or the issue of the immunity of a state official has experienced an important and very interesting change at the end of the last century, in particular, because of the development of international criminal law and for the process for setting up an international criminal system, including the establishment of the International Criminal Court. This new scenario has generated a new interest on the immunity of state officials. But these interests are linked with the new purpose of the international community to fight against impunity from international crimes. So it appears a new element that we have to take into account in order to define the legal regime of immunity of state officials. It is in this new context that the International Law Commission is working on the topic of immunity of state officials from foreign criminal jurisdiction, to which, as I said before, I plan to deal with tomorrow. Thank you very much, and I am ready to hear your questions, and I will be my best. I will try to do my best to answer to it. Thank you very much.
Thank you very much, Professor Concepción Escobar Hernandez. It was very, very clear and very didactic and also deep. Professor Concepción make a very clear distinction among state immunity and the immunity of state officials, and described the categories to read this important institute of international law and its implications to the geopolitics, to the stability of international relations. The distinction among immunity from habeas personae, habeas materia, the immunities among criminal jurisdiction, civil jurisdiction, administrative implications, and the personal implicated to these immunities, the high-rank officials, the other administrative servants, and the family. So she also mentioned some cases from the ICJ, quoted the European Court of Human Rights, Albasani, and we have several questions, Professor. So I will read it in block of 3 questions each time, and very interesting ones. So first, Luis Felipe Santana asked, I would like to hear from you if, in your opinion, absolute immunities of head of states, especially regarding the human rights violations, is coming to an end in our days. Second, Thais Almeida, good morning, Professor. I would like to hear your opinion about al-Bashir case in the ICC and the political consequences of the court's prosecution of officials, especially in the African context. The other one is from Hannah Leon. Professor Hernandez, could you explain the application of Article 98 of the Rome Statute and its relation with the state officials' accountability under international law? I selected the Article 98 just to quote for you and for our audience. Article 98 of the Rome Statute says, cooperation with respect to waiver of immunity and consent to surrender. 1. The court may not proceed with a request for surrender or assistance which would require the request state to act inconsistently with its obligations under international law with respect to the state or diplomatic immunity of a person or property of a third state, unless the court can first obtain the cooperation of that third state for the waiver of the immunity. 2. The court may not proceed with a request for surrender which would require the request state to act inconsistently with its obligations under international agreements pursuant to which the consent of the sending state is required to surrender a person of that state to the court, unless the court can first obtain the cooperation of the sending state for the giving of consent for the surrender. So I led with these first 3 questions. Professor Concepción, the floor is yours.
Thank you very much, Professor. I realize that every question are related to immunities with regard to International Criminal Court or with regard to international crimes. But I can understand. I can understand because at the end of the day is the most controversial issue and the most the issue having received more attention from the doctrine and even from the newspapers. Well, with regard to the future for absolute immunities of head of states, in particular, including the immunity for acts which constitute a serious breach to human rights. I think that if we think about immunity of state officials in a strict sensus, that means immunity of state officials before national courts, this I can see, to be honest, I can see that this kind of immunity is going to an end. That for several reasons. Tomorrow I will make some comments on that when I will explain the content of immunity ratione personae in the work of the ILC in the work of ILC. First of all, because immunity of head of state is a personal immunity. That means that this kind of immunity covers all acts performed by the head of state, both private acts and acts performed in an official capacity. Well, breaches to human rights could be considered as official acts. It depends, but to be honest, I know that I am in the minority position, but I think that they are official acts. Because if we consider that this kind of acts are not official acts, how is possible to attribute this kind of acts to a state? And how is possible to obtain the declaration of responsibility of a state? You know, it's a tricky argument. That is the first reason. And of course, there are private acts. That means that if immunity ratione personae covers both private and official acts, to use a short terminology, head of state are covered by any act committed as head of state. That means that the absolute immunity of head of state, from my perspective, is not going to an end. But which is most important for me is to put on the table the following thoughts. It is not relevant if immunity of head of state is absolute. It's not relevant for the protection of human rights or crimes, the fight against international crimes or the fight against impunity, because the immunity of head of state has a limited duration. Once the head of state ends their term of office, only the act performed in an official capacity could be covered by immunity. So if we consider that this kind of acts has been committed, or has been committed as private acts, the head of state will lose the protection provided by immunity. Even in the case that we consider that immunity, that this kind of acts are acts performed in an official capacity, we are before immunity ratione materia. And with regard to immunity ratione materia, we can establish some exceptions or limits to the protection given by immunity of state officials. One of the most, that is the issue, the most controversial issue now in the work of the International Law Commission, which is the draft Article 7 adopted by the Commission 3 years ago, establishing the list of crimes which are not covered by immunity of state officials. Which are these exceptions? Well, tomorrow we can have a more deep explanation of that, but of course, most of the breaches of human rights are crimes against humanity or war crimes or genocide. So they must be considered as exceptions to immunity ratione materia. Well, of course, the main issue is what happens if the head of a state is a permanent head of a state, or if the head of a state want to continue to be a head of a state in order to benefit from the immunity ratione personae. That is a factual issue. It's not a matter of law, it's a matter of fact. And if we look at the practice, we can see how, for example, al-Bashir, who has been fighting for continue to be the head of a state, to be protected before against the International Criminal Court, has been diminished, has lost her post of head of a state, and at that moment, no protection is covering the al-Bashir, the former president al-Bashir. Well, the second one, for me, for that reason, I think the more important issue is not the permanence of the absolute immunities of head of a state, but the most important is to obtain the assurance that the exceptions to immunity ratione materia will exist. Second, with regard to the al-Bashir case, I think that there are a great relation with between the second and third question, but I will try to make some comments. Well, the al-Bashir case, of course, the al-Bashir case has had a great incidence in Africa, even in the African countries, and in the African Union. Only I would like to recall only that some African countries called to the African Union to ask any member of the African Union to withdraw from the Rome Statute. Well, it's true that one had decided to retire himself from the Rome Statute, but it has not been agreed. The main state had decided not to go in the same way. But it is true that the al-Bashir case has had an important consequence or could have an important consequence on the new international criminal system, because as a consequence of the al-Bashir case, the African Union has adopted 3 years ago the Malabo Protocol, establishing a new chamber in the African Court a criminal chamber in the African court. Of course, the protocol, the Malabo protocol, is not enforced, but the most important element for me, the most critical decision included in the protocol is that this protocol excludes the principle that no immunities could be alleged before an international criminal court, an international criminal tribunal. Saying in the protocol set up the position to establish that the new criminal chamber will not address any case before a current state official. That is in the opposite side of the International Criminal Court. Well, the risk of the fragmentation of international law related to immunities before international tribunals is there, even if I think that we have to be aware the entry into force of the protocol is not an imminent fact. It will take a lot of time for entering into force. And but of course, the al-Bashir case has had great political, very important, serious political consequences with regard to the court of the International Criminal Court. And with regard to the last question, Article 98 of the Rome Statute. Well, that is the key. The interpretation of this article is the key for determining if immunities applies or not before, or if immunities of state officials has some incidence on the exercise of the jurisdiction of the International Criminal Court. Well, in fact, it has been the interpretation of Article 98. The interpretation of Article 98 has been the core element in the judgment adopted by the International Criminal Court in the Jordanian case. But I have to say that the International Criminal Court, the ICC, has declared that there are a customary rule who exclude the possibility to allege immunity before an International Criminal Court, to which I can agree. But even if the system of customary law, I think that so Michael Good will speak about the identification of customary law in the same course. You could put the question to him. He will give you a different answer than mine. But I think that I can accept that there are a general rule of international law avoiding the possibility to allege immunity before the ICC, at least before the ICC. Yeah, but it doesn't mean that because of Article 98. Immunity of state officials could not be alleged before national courts acting at the request of the International Criminal Court. I don't know if I'm able to explain what is my thought about that. Well, the ICC said, well, no immunity is could be alleged before the ICC. So no immunity could be alleged before a national court who is cooperating with the ICC. Because at the end of the day, the ICC the court consider that the national domestic court are exercising the jurisdiction of the ICC. Well, I can agree with that, but I think that we can go on this issue tomorrow. But the most important for me, I think that it is impossible to consider the significance of Article 98 without taking into account the Article 27 of the Rome Statute, who is the disposition establishing which made a clear declaration about the impossibility, about the fact that immunity at any rate can block the jurisdiction of the ICC. The only possibility is the ICC is not able to exercise jurisdiction at that moment because of the lack of cooperation, but the ICC don't lose the jurisdiction. Sorry for this long explanation.
Excellent, very, very clear. Just to highlight, also the Rome Statute is not open for reservations.
Of course.
So this is complementary. We have some other questions. The other question came from Leticia Hartel. It would be interesting if Professor could comment on the immunity of the US officials in Afghanistan. But I believe this will be addressed tomorrow. The other question came from Julia Peret. Professor Escobar, what are the exceptions of criminal immunity? Right. And we have also another question that from Leticia Hartel. Professor, what is your view on the Zelaya episode? Specifically on whether the Brazilian embassy in Honduras still enjoyed diplomatic privileges despite of the activities taking place there. This case, Professor, was the case where the president of Honduras was excluded from his territory, and he came back to the Brazilian, and he came to the Brazilian embassy and make speeches from the Brazilian embassy. I think it's similar to Assange. So this is also a case where the distinguish among state immunity, diplomatic, the Vienna Convention of Diplomatic Immunities from '61, and well, but I think you can make it clear. Those are also very interesting opportunities to make those distinguishes clear. Professor, it's closing.
Okay. Well, with regard to immunity of U.S. officials in Afghanistan, well, I can imagine that you are referring to the recent decision of the Chamber of Appeal of the ICC, declaring that the commission, the prosecutor is able it could be able to start the investigations. I think that is that. Well, the immunity of U.S. officials in Afghanistan could be analyzed from two different approaches. First of all, from the approach of the SOFA, the American forces in Afghanistan are on the basis of a SOFA that covers the activity of all the members of the military operation. And in this case, I think I need to review the test of the SOFA. I don't have here the test, but I think that in this case, the U.S. official could have some kind of immunity, not truly an immunity, but they could be free to be submitted to the Afghan tribunals, but on the contrary, they have to be submitted to the U.S. tribunals, who is not the same. It's not exactly the immunity, but that is not. But there are another perspective, who is the perspective from the International Criminal Court. Regarding International Criminal Court, the issue is the following: has the ICC has the capacity to open procedures against U.S. officials stationed in Afghanistan, according with the U.S. the Rome Statute? The answer is yes. The answer is yes for one very easy reason. For an easy reason. The International Criminal Court is competent for exercise jurisdiction with regard to every act performed for every person in Afghanistan, because Afghanistan is a party state of the Rome Statute. Well, there are other rules, but in this case, what does it mean? That is not, if we look at the immunity of state official from the perspective of the ICC, of course, it doesn't exist any immunity which could protect the U.S. officials. Regarding the exception are genocide, the following crimes: genocide, crimes against humanity, war crimes, torture, forced disappearance, and apartheid. There are the crimes included in the draft Article 7, adopted provisionally adopted by the ILC, and I will explain tomorrow more about that. They are not exception. For example, corruption, or the acts committed in the territory, but because of other reasons. Tomorrow I will explain more about that. And with regard to the diplomatic incident between Honduras and Brazil, I think that the issue is not an issue of immunity of state officials. Well, we can see the incident from the perspective of the diplomatic asylum, if it is possible to apply. I'm not sure. Second, it is a matter of diplomatic protection, not asylum, but diplomatic protection, the protection of people who are in the diplomatic locals, the embassy and other diplomatic locals. And I think that is not an issue of immunity of state officials. the fact that the declaration were made in the embassy of Brazil is not an element for conclude that there are a specific protection from the immunity of state officials. Thank you.
Thank you very much, Professor Escobar. I think we have written all the questions, and I'd like to offer our sincerest thanks for making us very clear this autonomous institute of international law. There is the immunities of state officials. It was very clear. It was brilliant explanations, and we will be back tomorrow at 8. Brazilian time. Thank you very much for your kind and didactic explanation and deep explanation. And I don't know if you want to make some other remarks for our ending.
From my side, I only would like to thank your coordination, the moderation of this panel, of this statement speech. Sorry, but I would like also to call the attention of all of our attendants about the risk to make a permanent confusion between immunities before domestic courts and immunities before international courts, because immunities has a different meaning before domestic court and before international courts. And if we missed this both of levels of both of kinds of tribunals, we risk to undermine the great success included, who was the inclusion in the Rome office, the statute of the Rome Statute of Article 27 and the establishment of one international jurisdiction able to act in case when national courts are not able to exercise jurisdiction. But I can understand that it's very difficult to be always to have always a clear line of for separation of both of jurisdiction. But I think that is essential to do it. Thank you very much. And tomorrow we will continue with the work of the ILC.
Perfect. Thank you very much, Professor Escobar. Thank you very much for our kind audience, for the questions, and they also acknowledged the answers, Professor. Well, we will continue tomorrow at 8. Goodbye.
Bye.
Goodbye, Professor Escobar. It was a pleasure to hear you. It was really a pleasure.
Thank you so much. But you know, my English is not so good, and I was always with some doubts about the speech. But I hope that it was interesting.
It was very clear. I didn't have any difficulty. The only one student asked to speak slower. That was the only. For me, it was very nice, but that was the only observation.
Okay, I will try tomorrow to speak lower.
Perfect. Would you recommend some text that you have published to subsidize this issue, because they are organizing some material to share among them? So if you.
I will check if I can send you some documents. Of course, I can send you Well, I think that I can send you, of course, the reports.
Mm-hmm.
The reports, my reports for the ILC, and I will send you I will send to Paula the quotes of the signature of the documents, and I will see if I have some specific because now I'm writing my course at the Hey Academy, and probably I can share with you the PowerPoint in English.
Oh, great!
Because it's broader than for this case, but it could be interesting for students to have some elements.
I'm sure it will be. Thank you very much.
Thank you.
Bye. Goodbye. Goodbye,
bye.
Professor. Bye, Paula. Thank you.
Bye,
See
Paula.
You tomorrow.
Thank you very much. See you tomorrow.
Thank you very much. See you tomorrow.
Bye.